Welcome to the show, Immigration with Tariq. If you've been following the show in the last 2 weeks, you must have read in social media because I posted everywhere. We'll be doing a special show on TOEIC cases today. Now, before I deep dive into TOEIC cases, let me give you a little bit of information on TOEIC, or maybe an update news on TOEIC, what's been happening recently. So everybody knows, I think it's common knowledge that back in May 2009, the former Minister for the Home Department made a statement in the Parliament saying that we will not take any adverse action against these students who have not used a TOEIC exam in any of the immigration applications. That was followed up by a policy guidance by the Home Office back in March. I think it was later updated in August, where the Home Office said that we will not take any adverse action against any student who has not used a TOEIC exam in any of their previous immigration applications. At the same time, they said we will give an opportunity to the student to respond to any allegation made against him on these TOEIC cases. In other words, if you follow up the case law, there was no right of appeal granted to these students, whereas now, due to the recent case law, there is right of appeal granted to these students. So where there is an allegation of TOEIC made against a student, he can lodge an appeal in the first tier tribunal under the human rights and try to clear their name. Now, if the appeal is won, I'll tell you what the policy says. If the appeal is won, the guidance says the student would, the applicant in this case, would be granted a 60-day visa. And then they have these 60 days to go to a college or university, try to get a CAS, and then seek an extension on the visa application. So in summary, this is all we know. Right of appeal on TOEIC cases. We know the Secretary of State has made a commitment, which was followed up by Priti Patel. She made a similar commitment that we will not take adverse action against those students who are found innocent and have not used an TOEIC certificate in any of their immigration applications. And the 60-day promise of a visa, which is on the policy guidance. Then recently there was an article in The Guardian where international students held a protest in the Parliament Square, where they said we feel cheated because the Home Office has not dealt with us properly, and we've been left in this limbo over several years in this litigation. Now that brings me to our special guest and why this guest is relevant and important to our conversation today. Our guest is Mr. Greg O'Kelly. Good afternoon, and thank you so much for joining us, Greg. Greg is an immigration barrister. Now, before I go into the conversation with Greg, I'll tell you very important information I have to give about Greg. Greg was involved in an immigration case in the upper tribunal, and in that case, there was a consent order made between the applicant and the Secretary of State. Now, let me explain a little bit about the consent order. If you have made an application against the Secretary of State in the upper tribunal, a judicial review application, sometimes before going in front of a judge, both parties have an agreement, a mediation, and they agree on certain terms. And the agreement is signed by both parties, and that's called the consent order. Now, this consent order is it's public information. In fact, Greg had a very interesting article back on the 4th of August, I believe you drafted an article, and he listed this, or he shared this consent order with the public. And what's very important in this consent order is one paragraph that states in summary, which we'll talk to Greg now in a second, is the concession made by Secretary of State that where there is an appeal allowed for an applicant under Article 8, and it's found that the applicant has not cheated in the TOEIC exams, the appropriate grant is a 2.5-year visa. Now, obviously, we're talking about a 2.5-year visa under the human right regime. So it seems as if the Secretary of State has accepted that where there is a allegation of TOEIC made against an applicant, and they win the appeal under the Article 8, and they win the appeal on the basis that they were innocent, they were not involved in any wrongdoing by the college or whoever where they did in the test. The appropriate grant of leave under Article 8 is a 2.5-year, meaning they go on the 2.5-year visa rather than the 60 days. Now, interestingly, when we look at the Home Office guidance policy, I personally, as a layman, basically someone who was looking into the guidance, could not find any such information which supports this claim. So I thought, all right, then why not we speak to Greg and have his view on this topic? And I think we have so many other questions I have for Greg. But first of all, thank you so much, Greg, for taking time and coming into the show today.
Thank you.
All right, I think I have so many questions for you. So let's start with the most basic question. Is there a Home Office policy that if I, as a student, win a case under Article 8 in the first day tribunal, should I be granted 60-day visa, or should I argue I should be granted 2.5-year visa under the human rights regime?
Well, I think the first thing is that it depends on what you mean by winning your appeal. If you establish that you have been, that you were wrongly accused of fraud, but the judge decides that it will be proportionate in any event to remove you, and you ultimately lose the appeal, then you should get 60 days in order to put you back in the position you would have been in but for the error. On the other hand, if you succeed in your appeal, as in your appeal is allowed, including a finding that you were wrongly accused of TOEIC fraud in circumstances where that's relevant, then you should be getting 2.5 years.
Now this is very interesting, because I know cases where, apart from other cases, where people have won the appeal in TOEIC, they have been granted 60 days visa. And of course, this is all prior to this consent order. So what can those students do? Because a lot of students will be listening to the show today. I hope they are. So what can they do? Because they've been granted 60 days.
Yeah.
They probably went ahead, my apologies, they went ahead, took admission at their university, college, and now they're studying. So can they make use of this provision or this concession by the Secretary of State?
Potentially. I mean, I'm interested to hear that you are aware of people who were able to make use of the 60 days. I mean, the point of the case that we brought is that most people couldn't make use of 60 days, because the classic example of somebody who falls into this trap is somebody who was studying in 2011, 2012, and did a TOEIC test then, had their leave curtailed in around 2014, and has had 5 years or so with no leave, unable to work, unable to study, either being funded by their parents or by friends, and they're not really in a position in 60 days to go and get a college and go and get the money to pay for a college and get the money to pay for themselves to be supported while they're at a college. So I think it would be relatively unusual that people would have been able to make use of those 60 days. But in respect to people who want to be able to make use of the concession now, I think probably the right course would be to make representations or include it in an application for further leave. I mean, if you're able to use those 60 days to get a college and make an application that was accepted, a student application, and you've got 2.5 years or whatever it is for the period for your college anyway, then I think it's much harder for you to make the case that you've really been prejudiced. But I'm not sure how many people will fall into that category. I think you're more likely to find people who, one, were only given 60 days and were not able to make use of that. And those people, I think, could make further applications based on this concession.
Then there's another category of applicants, I'm just thinking in my head because I come across them, where they were given the 60 days, but at the same time, as you know, they lost a lot of money with certain colleges because they gave tuition fees. In certain cases, they're ashamed to go back to their parents and seek further funding for their education, which led to them becoming overstayers, absconders in certain categories. So I'm sure there are people who are listening into the show today who back in maybe 2014-15 were accused of TOEIC. They were given the 60 days, let's give them that criteria, but they have not made another application because they didn't have the money and they've absconded since then, they've overstayed since then. How would you feel about those people, how they can use this concession?
I think in principle anybody who falls into that category could make an application for leave to remain based on this concession. I don't think, however, that there will be many people who do, because the whole thing that happened in 2014 was that the Home Office tried and fought tooth and nail to stop anybody being able to have an appeal. So there weren't really any appeals until we won the Assam case at the end of 2017. Until then, you didn't really get that many. And then it was following the Khan case in the middle of 2018 that the 60 days started to be given up. And that was pretty much on the basis of an agreement between the parties there. And I think it seemed to everyone at that stage that, well, at least we should be able to put the students in a position that isn't worse than it would be if your college lost their license, for example, where you get 60 days. Because that seemed to be sensible. But the reality is that if you've spent 5 years unable to work or study or do anything and have spent all your family's money and can't get any more money, the 60 days is basically useless, because people need enough time to be able to earn enough money to be able to then go and get their education back on track.
So in essence, one could attempt, if even one is an overstayer and absconder, make an application and make a case for themselves on the basis that they were left in this dilemma or in the situation due to the historic injustice by the Home Office or the action taken by the Home Office, if they're claiming they were not involved in
Yes.
in the wrongdoing in the first place.
I think that's right. I mean, I think that gets more difficult the longer you leave it. I mean, the Assan case is, like I said, I think it's November 2017. Khan is, I think it's June 2018. And I think, the longer you abscond and the longer it is before you actually try and regularize your status, the harder it's going to be for you to explain to an immigration judge, because realistically you're probably looking at an appeal, why you didn't try and clear your name earlier.
Excellent. And this is just fascinating to me because there are so many people I have met, I've come across who've been involved in this toeic saga. And it's just fascinating that how much we've moved forward in this case, and yet so much little information is out there in the public domain, so to speak.
Yeah.
And even I think something like this, this case itself, which is I think an unreported case at the moment.
Well, it's an unreported case because the Home Office conceded, so we didn't actually go to court.
Yes.
We lodged the application and the Home Office settled. And the Home Office, to be fair, their position was that they said their position was that their policy was intended to cover this situation, if I recall correctly. But the reality was that if you looked at their policy, it didn't on its face. It's a little bit better now, but I think their policy didn't appear to cover it, and that's why we needed to publicise the concession. We needed to publicise the consent order so people could rely on it.
And just to clarify that if, as a young practitioner, somebody wants to use this consent order, an applicant, in their application, are they allowed to keep a copy of this consent order and say, look, this is what we know from the public information, quote the case law, and say, could you follow and give us 2.5 years? Is that permissible? It's
absolutely permissible. I mean, nobody realistically is going to be able to do that unless they've already won their appeal. Yeah. So you have to be talking about people who've already got their 60 days and it hasn't worked out.
Exactly. Thank you so much for that. I think before we take any calls, I think we can summarize, which is the most important thing, that everything is case-by-case basis. There are a lot of variable factors that have to be considered. I don't think the format of the show is that we could discuss all the variable factors. So I think the most important thing for any potential applicant who was involved in a toeic case is to take the appropriate advice. Go to someone who's competent. Either you book an appointment online, or you could contact a barrister directly who provides direct access, or you could ask your lawyer or legal representative to book a consult with one of the barristers. And I think it's very important that rather than you making a presumption leap of faith that, oh, I'll be granted 2.5 years, you take your case to the appropriate person, and they could have a conversation with you, ask several questions to you, and then give you a very clear idea whether your case would be successful or what merit is in your case under this regime. And I think what Greg has said made a lot of sense, that it is primarily for those people who have won their appeal. In other words, people who have their human rights appeal have been allowed on the basis that they were not involved in any wrongdoing. So it's slightly different to what the Secretary of State said in the ministerial statement. So they're two different things. Thank you so much. Now, I hope we get callers today, because we have Greg and we're going to use him to answer your calls today. So I hope we get callers. We have callers who would be addressing the toeic issue. At the same time, in my ear, I've been told that there would be a break in about 40 seconds. So why don't we quickly take the first caller, and then we're going to go on a break. We'll come back, answer that question. So please, I would be grateful if everybody who's ringing in today would raise issues regarding toeic, because Greg is here and I really want to use his expertise in the matter. So let's take a first caller. Hello? Hello? Hello?
Welcome, sir. Good evening.
Good evening to you. Yes, you can ask your question. Yes?
सर बर्मिंघम से बोल रहा हूँ. मेरा क्वेश्चन था सर आपसे ये कि मैं ना 5 साल का कार्ड है मेरे पास, अनमैरिड पार्टनर हूँ मैं, बट 2 साल के बाद हमारा थोड़ा सा रिलेशन भी झगड़ा हो गया. मतलब तो आप कुछ सकते हैं कि रिटेन राइट का जो डिफरेंस है अनमैरिड पार्टनर जो मैरिड पार्टनर होते हैं, कुछ हो सकता है या कुछ भी नहीं हो सकता. अभी 2 साल ऊपर हम साथ में रह रहे हैं, 2 साल से ऊपर, 2 साल और 3 महीने हो गए हमें रहते हुए. अभी हमारा ब्रोकअप हो गया है.
All right. Thank you so much for your call. I think we're going to go on a break. Then after the break, I'll ask your question to Greg and we'll get you an answer. I would request everyone who's calling into the show before we go for a break that please, if you could try speak in English, otherwise not a problem. You can ask me the question. I can translate to Greg the question. But I would prefer if today, because the format is we're going to talk about toeic cases, I'm very hopeful there will be callers who would be discussing TOEIC cases with us, or if they were a victim of a TOEIC case, and that we could discuss their case and we could get them some information from Greg. At the same time, we're going to go on a break right now. Before going to the break, thank you so much for sharing our channel on social media. Keep doing that. We're going to go on a break. When you come back from the break, we're going to ask some more questions to Greg. And first, we'll answer this question about the unmarried partner under the EU regime. Thank you so much. We'll see you after the break. Welcome back to the show, Immigration with Tariq. As I mentioned earlier, today we have Greg O'Kelly, a barrister, immigration specialist, and I, as I mentioned in my promo, which has been running for over 2 weeks, that I would prefer and I would request people to ring in who have TOEIC cases issues. And because I want to use Greg's valuable time, I've got a lot of questions when I go through with him. But before we ended our first session, there was a caller who mentioned that they are unmarried partner, and he was looking towards a retained right of residence. Now, the retained right of residence requires you to be married to an EA national, and the marriage should last for 3 years, and out of those 3 years, 1 year should be in the United Kingdom. Now, because you're an unmarried partner, you do not meet the criteria because the marriage never took place. So the retained right of residence would be a small problematic issue for you. But having said that, I think it's very important you seek competent advice from a qualified person. Go and discuss your case with them. But that is you could say, the hurdle I see in your application for retained right of residence under the EU law, that it requires you to be married to your partner, your sponsor. In this case, you are an unmarried partner. But anyway, Greg, coming back to the TOEIC cases, I think my first important, we've discussed that time is of essence.
Yeah, that's right.
And people should, of course, take competent advice from a qualified person and discuss the individual merit of the case and individual circumstances of the case, because I think what I've established having conversation with you, it's not an open policy, it's case by case. But what can an applicant do to prepare the case?
Well, before I get on to that, and I think that is really important. I think one thing you said there is vital, which is to get competent advice. And I have seen, in particular in TOEIC cases, a lot of people get quite bad advice. Yeah. And one of the really frustrating things that I've had, because I've done a lot of these cases now, is that people have come to me at a stage where everything has already gone wrong, and it's a lot harder to repair the damage than it is to get it right the first time. So whoever you go for, make sure you've looked into them and you're happy that they're good enough. In terms of preparing the cases, I think it's really, really vital. And when I'm doing them appeals in the first tier tribunal or the upper JRs in the upper tribunal, wherever it ends up, the difference between winning and losing is preparation. You're often trying to prove that somebody had a good grasp of English in 2011, 2012. The Home Office evidence in respect of TOEIC stuff, in my view, is very weak. I don't think they were justified cancelling the visas in the first place. I think it's really, really poor. But all the same, clients need to be able to show that they had good English at the material time. So, you need a really good witness statement. You need a really thorough witness statement that deals with your experience of going and taking the test, why you took the test, where you took it, whether you saw anybody cheating while you were there. And it also needs to engage with the standard of English you had at the time, your educational achievements. And if you haven't, for example, challenged the decision that was made in 2014, why you haven't challenged the decision.
I think that's a very important point. Yes.
Exactly. I mean, the Home Office are slightly two-faced about this, because they will say they denied everybody a right to appeal in 2014. And then in 2018, in an appeal, they'll say, why didn't you appeal in 2014? Well, of course, that's why. In these cases, it's absolutely vital to get witness evidence from other people. Yeah. So a lot of people, most people who had their leave curtailed would have been students. They would have been students in 2011, 2012, 2013. Yeah. If you wrote a master's thesis in English in 2013, then I want that in the bundle. If you had a lecturer who saw you regularly give presentations in English, then I want that lecturer giving a statement.
Oh, wow.
You should be able to get students who were there with you, friends who were there with you. Sometimes you get people's flatmates to say, well, we were, the client is from Bangladesh, but the rest of us weren't from Bangladesh. We all spoke English in the house because that's the language that we spoke. You want to have people who will testify as to the quality of your character, I've had people have their bosses say, look, this is a guy we trusted to manage the money in our restaurant. We don't believe for a moment that he would have cheated in an English language test. Or someone else employers are really good. So if you could get somebody to say, well, this guy was working in Tesco, dealing with customers every day, well then obviously he had a standard of English. That meant he didn't need to cheat in a test. So those are the kinds of things you want. But what I really emphasize in these cases is that you want as much evidence as you can. And you want to be really thorough.
And I think what you touched on is also very important, is that if there is a delay between your 60-day expiration and now you're coming out of the woodworks to make an application, what was the cause of the delay?
Exactly.
You must give a very, very clear and very credible explanation as to why for the 4 years, 3 years, whether it was you were ashamed of your family, asking them for money, whatever. But I think that's also very important, that the delay itself has to be addressed. Or is that also part of the equation?
I think that's also part of the equation. It's part, I think it's an equation. It's part of the equation in almost every aspect of kind of long residence type immigration cases. If you vanish for 5 or 6 years, it doesn't necessarily help your case that you were genuine in respect of whatever it is that you said was going on. But it is something that in TOEIC cases, in every first tier tribunal appeal that I do, the Home Office will say, well, why didn't you raise this issue 2-3 years ago? And they'll often say, why didn't you write to the Educational Testing Service to challenge them? As if your average student is going to write to the Educational Testing Service Corporation to ask them to explain themselves.
Yeah, they require the applicant to have a little legal expertise to some level. I understand that.
Yeah. Well, but the problem with it is, the average student wouldn't know enough to do that.
Yes.
And anybody who had legal expertise would know that if you write to the Educational Testing Service, they won't write back.
Yes.
So, it's you're damned if you do and you're damned if you don't.
And the other thing just came into my head now is that the cost of an individual application to an individual might be too much. Then if they're looking at to judicially challenge it, first day tribunal, follow it up.
Yeah.
Is there a possibility to get a cohort, when I say cohort, a group of students together, I know you know cohort, but it's for the other listeners, is to get a group of students together, maybe 5, so if they have the same characteristics, make an application as a singular application. I know there'll be individual applications, but try to link the case together. But that way they can spread the cost when it comes to the tribunal fighting the case against the Secretary
An
of State.
application for leave to remain.
Yeah, basically they make
a group application for leave to remain.
They could pay the individual fee.
Yeah.
And let's take the presumption they'll be refused. But then for the appeal, they can ask for the tribunal to link their case. Then they can go to one barrister, and say if the cost for that appeal is, we're not quoting anybody's cost here, but say the cost to represent a case is £2,000 for a barrister. Instead of one person paying the fee, if they link the case, then all 5 could pay that fee. So is that a possibility, or doesn't work practically?
I'm not sure about the mechanics and the practicalities of making the application. That sounds like a good idea. The only thing I would say is that when it comes to the appeals, every single case in the Court of Appeal, the High Court and the Upper Tribunal, they all say that these cases are intensely fact-sensitive. That's the expression they use.
Yes.
I think it would be really dangerous to run a number of them together, because if one of them
fails, then it is a domino effect.
Potentially, yeah. And the Home Office can suggest that people prepare their evidence together, or I think it would be very risky, and I'd like to take each of my clients individually and show why each of them absolutely couldn't have cheated in the test. And I think it's harder to do that as a group. And then
I get asked a question a lot. Can I seek compensation from the Home Office? And I'll tell you the background to it, because a lot of these international students, for example, I can't take a name of a college, but say a limited college. They don't know who the college is. They don't know the owners. They go on the Home Office website, type in highly trusted colleges. Name of the college comes up. They paid £10,000 to join the college. In certain, I think, colleges is more than £10,000. Then one morning they're going to the college. It says the college has been revoked. They get 60-day letter. Now, a lot of these students I have spoken to say, can we seek compensation, because our £10,000 is gone. The Home Office doesn't want to know anything from us. And they instead insisting in 60 days, go find another college. When we go to another college or university, they want the fee all over again. Our awarding body, and this is fascinating what I've found out, that a lot of these students are doing external examination with awarding bodies. In certain cases, they spend 8 months in a college, and say the awarding body would say on the 12th month you'll be given a certificate. When they go back to the new college,
Yeah.
They contact the awarding body, say, sorry, you'll have to do everything all over again because we have cancelled the license for the previous. So is there any compensation for these kind of students from the Home Office? And what kind of procedure is for that?
Well, that's not strictly a TOEIC issue. That's something that applies a bit more widely. But I think the first and most obvious point of call is the Ombudsman. And that's something you should really look at. And a lot of people don't seem to be aware of the fact that there is an ombudsman and that there is, they do make, reasonably good awards sometimes. I think also you probably need to look at whether there have been any torts. Now, in the context that you're describing, I think what you're talking about is something closer to negligence. You're not going to get anywhere with misfeasance in public office. It's way too high a threshold. Yeah. And maladministration isn't something that you're going to get damages for. You are getting close to negligence. Negligence traditionally is something that you can't sue for in respect of the context of a government body carrying out its statutory functions or exercising statutory discretions. That isn't necessarily as crystal clear now as it always has been. There's a case last year in the Court of Appeal called Hewson, which suggested in the context of somebody who had experienced a substantial delay in getting a residence card after the Home Office had effectively undertaken to do so, that there was a duty of care, arguably for negligence purposes. And the law of negligence is quite malleable at the moment, so it remains to be seen. But I think, in general, it's going to be quite difficult for those cases. And my instinct would be, if it's just a situation with a college, I would probably be heading down the alleyway of going to the Ombudsman. You have to bear in mind that the courts have given a lot of leeway to the Home Office in the exercise of the points-based system for students.
I've seen, and then they've been criticised in certain cases at the same time. But yes. Now, another fascinating thing I had to ask you. Of course, this change in policy or the statement from the Secretary of State came in May 2019. Where they said anyone who's not used a TOEIC exam in any of the... they will not take any adverse. Yes. Yeah. Now, interestingly, there were people who made nationality applications prior to this statement. They've been accused of using TOEIC, and they've been refused their nationality because of good character requirement. And now the policy says on nationality that if you refuse your application, say somebody gave TOEIC in 2013, they somehow managed to apply a nationality application in 2015. Because in the last 10 years they were involved in deception, whether taking a test, not taking a test, they were refused the nationality application. And then said, after 10 years you can make the application because they look back 10-year period. Now, technically, those people who have got indefinite leave to remain, sitting with a waiting for the 10 years to expire when they were alleged for TOEIC for some reason, didn't go to court. They can make a case, in your opinion, can they make a case making a fresh application for citizenship and then using these case laws of Khan and Eisen and say, look, we were never granted a right at the time. We were not involved in any wrongdoing. We were only convicted from this third-party information, which then later found was insufficient. Can they make an arguable case and at least apply for nationality? Because as you know, nationality is discretionary. Anyway.
It is discretionary. Nationality is much more difficult. And it's not a right of appeal against the refusal of nationality either. I mean, the whole point of the indefinite leave to remain and the human rights stuff is that you can get it into the tribunal. You can make a judge look at the evidence and make a decision on it, which is much more difficult in the nationality context. I think, I'd have to look at it, and I haven't really thought about it before, but my instinct would be that there's no reason that you couldn't make those kinds of representations with a further detailed application. Treat it as if it were, in fact, an appeal and say, this is all my evidence that I never would have done anything like this. This is the case law suggesting that the Home Office evidence isn't as ironclad as you thought it was. And say that there's not a basis, therefore, for excluding me from nationality. I mean, it does raise quite interesting issues, actually.
And now we come to the most important cohort of students, in my opinion. There are thousands of students who, when there was an allegation made against them that you were involved in wrongdoing in TOEIC, they didn't have the funding to appeal or didn't have the money to go and take admission in a new university and college, and they returned home. And there are thousands of them.
I suspect there's tens of thousands.
Yes. Now, what can they do? Because you see where they can see from, say, if somebody's sitting in Nepal, what they can see now is, first of all, they should have been granted a right of appeal. They should have been granted an opportunity to respond to the allegation made by ETS. And thereafterwards, they could have then addressed the issues with the Home Office. So what is the remedy for, because some of these students, ex-formal students, are sitting back from 2012 and 13, and all these amendments happened in 16, 18, the recent statement in 19, then of course, very important in your case, and I must stress to all students or young immigration practitioners that you need to go and have a look at the article written by Greg on the matter. I think later on.
I think the article was written by Bindmans.
Yes, I think, but I think it's very relevant to all this case. And I think the key thing I'm saying about the article is that this consent order is public information, and you could use that, but don't use it for the application initially. I think it's very important you go and take advice from a competent person. So, I mean, get back to it. So, what can those students do now, the formal students? Because I know it's very expensive to apply again from abroad, especially with a adverse immigration history, because when you make an application, they ask for it on the application form. In the last, it used to be 10 years that, have you ever had any adverse history? They'll say yes, and they'll give in all this explanation. I mean, because there's no right of appeal for them either. So is there any way they could argue human rights application from abroad, saying, look, what's done to us, and is there any remedy for them?
Well, I mean, I think in principle there is. I think in principle they could make that application from abroad. The question is, how would they be able to actually have a fair hearing if they're still abroad? Because you basically you need to be here if you're going to gather the evidence of what was going on at the relevant time, and you need to be here if you're going to have a proper kind of in-person hearing where you can be cross-examined. So I think that's quite difficult. In fact, part of the whole Assam case was our contention, which we successfully made, that they couldn't have an out-of-country appeal successfully.
And that's what the judge
fairly,
agreed on,
rather, the Court of Appeal accepted that. So I think it's quite. I think it's quite difficult. I think it would have to be some kind of entry clearance application on the basis of human rights. And what you'd be arguing would be about, the fact that your human rights were breached by you having been in the middle of your education and having your life effectively destroyed. In a lot of cases. I mean, particularly people from Bangladesh who want to go into civil service. I mean, it was ruinous what happened to them. But also I think there's arguments to be made about, and this hasn't been determined yet anywhere, about the impact in Article 8 terms on your reputation.
Yeah. Oh yeah, that's a very good point.
Because people have had their good names destroyed, and if you come from a family who've spent a lot of money putting you through an expensive education in another country, that's something that matters a lot to people, and people have been left without a remedy. So the issue you raise hasn't been dealt with anywhere. I've looked at it in one case so far, and we'll probably be looking at it in more. But I think there has to be a remedy. That needs to be something that we look at now.
Yeah, I think that's fascinating because there is this cohort of people who've gone back, and I think some of them, you rightly said, they were appointed by the employers to come and do a degree here in certain cases abroad, and they've gone back with their reputation in ruins, where the employers said, why have you come back? We just paid for your education, and they had to turn around and say, and it's just fascinating. We're going to carry on the conversation with Greg, and I'm really, really finding this fascinating. I hope the students sitting at home who are involved with TOEIC, former students, past students, they find this quite useful. Going on a break, thank you so much for logging in today, and I hope you're really finding this show informative for yourself. So we're going to go on a break. When you come back, we're going to pick more brain off Greg, and we're going to discuss TOEIC issues. I have so many questions, but because we have very limited time in our format in the show, so I'll get back to you after the break. See you after the break. Welcome back to the show, Immigration with Tariq. As you've been following the show, today we have a special guest, Greg O'Kelly. He's a barrister, immigration specialist, and where Greg's specialization, apart from other aspects of immigration, is TOEIC cases. And as I mentioned, and you've been following the show, that there was a very key TOEIC case recently that involved a consent order with the Secretary of State, where there was a concession made by the Secretary of State that anyone winning the case under Article 8, where it's proven in court they were not involved in any wrongdoing on TOEIC cases, they should be granted a 2.5-year visa under the human rights regime. And I think that's very, very crucial to the conversation we're having today. I'll summarize everything later, but I think the key thing which we are homing in towards you is preparation is key for any application, and please do not take this consent order as a blanket cover for all applications. It matters from case to case. So it's very important you go to a competent person for advice, so they can ask all your information, seek individual clarification, and then tell you what the merit is in your case if you pursue making a 2.5-year visa application to the Home Office based on the fact that they've never given you an opportunity to fight you. Because I think one thing Craig was very clear about, that the first port of entry or the first hurdle is you clearing your name against TOEIC allegation. Then comes the 2.5 years. So I think that clarification is very important. Don't think that if you've been deemed that you were involved in the wrongdoing, that you could make use of this policy, which is mentioned here. Now, I think during the break we're having a discussion, and I think it's a very important point you raised, that the first time an applicant goes into the first tier tribunal, just explain to us, because he was explaining to me during the break as well, that why is that decision very important? Because it has an effect on your ongoing applications as well. So just explain that why the first time I as an applicant go into the court, why is it very important for me to get it right in court, the correct preparation, and go in front of a judge and prove that I'm a credible witness?
Well, for a start, it'll be, in a lot of cases, the first time anyone's had a chance to prove their case. You know, a lot of the TOEIC victims have not had the chance to clear their names, basically, for years. But it's really important because you have to get it right. It's very hard to overturn findings of fact made at the first tier tribunal. So if you haven't got your prep right, if you haven't got your evidence right, it's very hard to then raise that again at a later date. And it's very hard to convince an upper tribunal to overturn a first tier tribunal decision where they think, really, you just wish you'd raised more points earlier. And that doesn't just go for factual points. It's also really important that you raise the right arguments. And something I see that's quite frustrating, people come to me to draft grounds of appeal when the important issues weren't raised at first instance, or the evidence wasn't there at first instance, and that's something that's really difficult. So you really do have to get that right. I would say, though, that, you know, in regards to the concession you discussed earlier, so the Sajid Javid's concession, there is a real tension, and it's kind of unfair for people with kids, or for people who have never relied on a TOEIC test, because under the concession from 2019, people who didn't rely on a test will not generally have TOEIC action taken against them in a new application, and people who have kids in the UK will have special consideration. Now, if you have children and your application is pending, and you've had this accusation made against you, there is kind of pressure on you not to try and clear your name, because it's safer, isn't it? And it's really unfair to put people in that position, but that tension is there, and it's something, you know, tactically when I'm speaking to my clients, I sometimes do have to say, look, I think you didn't do it. You tell me you didn't do it, and we've lots of evidence of that. But at the same time, if we point out the concession, the Home Office will have to not rely on it. And it's not the same as being able to tell your family that a judge found that I didn't do it, as being able to say that that the accusation is withdrawn. So I think it's really unfair.
And this is fascinating what you just said, because it's very important to prep your case, because if the judge finds that you're not a credible witness, that tag carries on, because there's case law. Yeah. That every time you go for a second hearing, third hearing, the judge will pick up what was said in the first hearing. And if they did not find you a credible witness, that will be brought up by the Home Office. First thing they'll say is, here's the principal case law that says starting point is the first determination. The judge found you are not a credible witness, and that will hinder your future applications as well.
It depends on what kind of application. So if you were found not to be credible in your asylum claim in 2011, that might have very little to do with whether you were credible on the issue of TOEIC in 2020, and vice versa. On the other hand, if it's the same basis, then obviously we've got the Devas-Sealand principles, and obviously then the previous determination is a starting point. So it will depend, but you can absolutely be certain that if you are found not to be credible in a TOEIC case now, even if you're allowed to remain in future cases, if there is some kind of appeal, that Home Office will absolutely rely on that.
And then there is the other category on this side of applicants who maybe lost the case in the first tier tribunal. And now, as you know, there is a process of further reviews and appeals to the first tier tribunal, upper tribunal to the very least. So there could be someone at the moment listening in who lost the first tier tribunal. Forget they were well prepared or not, they realized the mistake either way, but there is an application made in the upper tribunal on an error of law. And they come across your consent order now. Now, the initial application is on an error of law. And in the upper tribunal on error of law application, unless the court decides to, they cannot submit further evidence. So how can they introduce this new piece of evidence, which is a concession unknown to most public? I mean, I'll be honest with you, before you made it, or the article made it public, it wasn't known quite commonly that there is an internal policy where the Home Office may concede on granting 2.5-year visa to applicants who are found innocent with these kind of cases.
Well, that was the point of the of us taking the case, was because we thought there should be a policy saying that, and we tried to force the Home Office to do it, and they conceded the case and gave us that concession. But I mean, I don't think anybody can rely on that concession in court. It's not going to help them in court. What's going to happen is it'll help them if they win their appeal.
Oh, okay.
They need to win their appeal, and that concession will then be a basis on which they should get leave to remain.
Yeah, it comes back to the same thing we were discussing earlier. Step one, they need to win the appeal. So step one,
get it right first time.
So I think the step one for any applicant is to clear their name of the wrongdoing done through the allegation of TOEIC, whether they use the case law of Khan or Essen to get that appeal right. Now, in the same instance, there is another category of clients, we discussed this today, who lost mainly because they were not given the appropriate advice. I meet sometimes clients who say, oh, well, I had a friend who went with me to give the TOEIC exam. And I said, hold on a second, but when I'm reading your determination, it's not mention of the friend, there is no witness statement, did he go to court? No, he didn't go to court. So now we know, and I think a lot of people now who are involved in TOEIC cases know that the preparation is key into these cases, which you've rightly raised. And I think people read a lot on these websites and they find out about these cases, and they've been reading on what's said in court. Now, what can these people do? Because I say I am a student, I lost my case, hands up. But honest to God, I was not involved with it. I was giving bad advice at the time. I was not told. I had ample evidence, but I wasn't informed. I could, like you mentioned today, I could have gotten you an employer letter. I could have given you a university thesis I wrote. I was writing an article somewhere else. I had friends who were English speaking. I, in fact, did a seminar and I spoke in English. So none of this was asked for me by my previous rep. I lost the case.
There is an answer to that.
Yes, that's the key now. What can I do with those cases if I'm in that category?
I would treat it just as I would an asylum claim that have failed, in that if there's more evidence, it's the proper basis of a fresh claim. I would make that fresh claim. But one thing you need to bear in mind is in almost all of these cases, the Home Office has been relying on the statement of Rebecca Collings, Peter Millington, Professor French, a covering statement, and then a couple of other kind of generic pieces of evidence, and then evidence of an individual having been put on the list that says they failed. All of that evidence ends in around June 2016 and doesn't take account of the fact that ever since then, there has been loads of evidence brought out in the test cases in relation to the IT process, which shows that the Home Office evidence wasn't reliable. So basically, the Home Office evidence is that a person's voice file has somebody else's voice on it. But the evidence since 2016 shows that there's no way of telling whether any individual's voice file has been properly matched to them. There's no chain of evidence at all. And the fact that the Home Office knew that and continued to rely on that evidence and put that in front of the tribunal without telling them about the subsequent test cases, without telling them about the subsequent expert evidence, in my view, is a proper basis for a fresh claim. And not only is that my view, I've actually won a couple of cases arguing that, where they've conceded that a person should have a fresh right of appeal, where they can raise issues that weren't, where they can have a proper appeal, where they're able to put the proper evidence before the tribunal, including the weaknesses of the Home Office's case, which in my view alone is a basis for a fresh claim. Yeah,
because that's fascinating, because there are tens and thousands of students on the side who have now become absconders, but they've lost the appeal at the first stage tribunal. I've come across a few of them, but when they have lost the appeal, is because of bad advice, I'll be honest with you. So even there is a window for those people to, again, it'll be case-by-case basis, for those people to come forward with new evidence, make a fresh claim, make the legal argument based on what you said is mentioned in 2016 onwards, all those legal. But again, I think it all comes down to competent advice, preparation, and I think seek individual advice before.
It'll depend on the individual facts. I mean, some cases will be very strong, some cases it won't be worth doing it at all. Although ironically in these cases, the fact that you had bad advice is sometimes almost an advantage, because if you didn't have decent lawyers, they won't have brought the tribunal's attention to the stuff after 2016, which actually makes your fresh claim arguably stronger.
Yes, because it was not mentioned in the previous.
Exactly.
Great. I tell you what, I wish we had another hour, because this is fascinating, but I hope we covered a lot of these issues, and I try to address with you a lot of these questions raised by people I meet, ex-students, past students, and people who are facing these issues. So thank you so much for coming in today, and we hope we'll get you in the future. because I know you're an expert on elderly dependent relative visa applications as well, and we get a lot of inquiries on that. Maybe that's for another day. But thank you so much for today.
Thank you very much for having me.
I hope you found the show informative and what we've discussed in the show. And I think the key things which we can drive from the show, number one, do not take this consent order as a blanket cover. You must go to a competent person and take legal advice, and then case by case basis, they will make an application for you. So there's 4 or 5 things which are very clear right now. Number one, there's no such thing as 2.5-year visa till you're proven innocent in the allegation itself. So first thing you have to do is clear your name against that allegation. If you've never raised an application, you could use the recent changes in the case law through Khan and Essen, and then make an application to the Home Office seeking an in-country right of appeal to the allegation they raised against the allegation, saying you were never given an opportunity to address the issue. That's number one. Then you also have a cohort or certain group of people, and that's why I raised with Craig, who have lost their appeals. Went to court, they've lost the appeals, but they could have lost the appeals, or they may have lost the appeals because of the bad advice. Now, Greg pointed out very rightly that there was a change in legislation June 2000 onwards, I think it was 16 onwards, which reflected a lot of changes in the Home Office evidence. So I think, again, you should take competent advice, and if you fall in that category where your legal representatives at the time did not address the court with the appropriate material, then you may be eligible to make a fresh claim and say, look, these are the facts now, and I want my case to be readdressed by the Home Office, and I'll be given another opportunity to clear my name. And I think, again, it's not a blanket cover. It's very important you take the appropriate legal advice. I would say before going that for legal purposes, we can't display the name of all the guests here. I mean, the chambers our guest belongs to, but obviously at the end of the day, there are articles and there's information available on Greg O'Kelly, who's an immigration specialist. Thank you so much for logging in today. I hope you found the show useful, and very soon we will ask Greg to come back and maybe address another visa, which is the elderly dependent, because I get a lot of questions asked for that. Good evening to you, and inshallah ta'ala, I'll see you next week, again with the show, again with some questions on immigration. Take care of yourself and see you next week.